Before we begin, a quick and important disclaimer. The content provided in this video is intended strictly for educational, research, and entertainment purposes. While we will be analyzing the historical evolution of matrimonial law, marital dissolution, and legal frameworks in the United States, as they pertain to historical fiction and literary analysis, nothing in this presentation constitutes formal legal advice. Legal systems change over time, and historical trends do not reflect modern statutory frameworks. Viewers should conduct their own independent due diligence and consult with qualified legal professionals for any real-world legal matters. Imagine a historical fiction novel set in Gilded Age New York. The heroine, trapped in a loveless and emotionally stifling marriage to a wealthy industrialist, decides she has had enough. She packs her leather trunks, walks out of her Fifth Avenue mansion, hires a sympathetic lawyer, and within a few chapters secures a clean divorce, keeping her independent fortune and full custody of her young children. To a modern reader, this feels like an empowering, triumphant arc of self-actualization. To a historian or a serious analyst of literature, however, this entire sequence is an immersion-shattering lie that completely trivializes the terrifying reality of women's historical lived experiences. The comfortable, streamlined divorce journey we frequently see in contemporary historical fiction is often an anachronistic fantasy projected backward onto an era where ending a marriage was equivalent to social, financial, and legal suicide. For the vast majority of American history, a married woman did not exist as an independent legal entity. Under the legal doctrine of coverture, inherited from English common law, a woman's legal identity was completely suspended during marriage and incorporated into that of her husband. She was a femme covert. She could not own property in her own name, she could not sign contracts, she could not keep her own wages, and she had zero legal rights to her own children. If she fled an abusive husband, she was legally a fugitive, and anyone who sheltered her could be sued by her husband for harboring stolen property. When historical fiction minimizes these structural barriers, it robs the narrative of its genuine stakes. It replaces a harrowing, high-stakes battle against the entire weight of the state and society with a lightweight modern melodrama. The open loop that every storyteller and historical analyst must confront is this: how do you authentically portray a character seeking freedom when the legal, economic, and social systems of their time are deliberately engineered to ensure their absolute subjugation? Understanding the actual mechanics of historical marital breakdown is not just a matter of pedantic fact-checking. It is the ultimate tool for unlocking deep, resonant conflict in historical narratives. By examining historical trends and specific case studies across different eras of the American landscape, we can uncover the profound friction between individual agency and institutional control. This masterclass series is designed to solve that exact problem for writers, readers, and history enthusiasts today. It bridges the gap between shallow, inaccurate representations of past relationships and the deeply compelling, historically accurate realities of marital dissolution. Over the course of this deep dive, we will unpack how the legal definitions of marriage and divorce evolved from the colonial era through the mid-20th century. We will explore how different regions within the United States handled the concept of a broken marriage, revealing a fractured landscape where a character's fate depended entirely on the specific colony or state they inhabited. For instance, consider the striking geographic disparities found in historical trends. While early New England Puritans viewed marriage as a civil contract and allowed absolute divorce under strict, specific circumstances, the Southern colonies, operating under Anglican influence, offered no judicial mechanism for absolute divorce whatsoever. In fact, South Carolina did not permit judicial divorce for any reason from the end of the Revolutionary War until the mid-20th century, with a brief, volatile exception during the Reconstruction era. If a narrative features a planter's wife in 1830s Charleston, easily divorcing her unfaithful husband, the plot collapses under the weight of historical impossibility. By analyzing these regional variations, you will learn how to turn the setting itself into an active antagonist or an unexpected ally in a character's journey. We will examine the transition from legislative divorces, which required a literal act of the state legislature and a massive amount of political and financial capital, to fault-based judicial divorces, which forced individuals to put their private miseries on public display in a court of law. This shift introduces immense narrative potential. To secure a judicial divorce in the 19th century, a character could not simply cite irreconcilable differences. They had to prove specific statutory faults, such as extreme physical cruelty, long-term desertion, or adultery. This requirement turned the courtroom into a theater of public humiliation, where neighbors, servants, and family members were called to testify about the most intimate and sordid details of a couple's domestic life. Furthermore, this series will examine the devastating material consequences of seeking freedom, focusing on the evolution of child custody and property laws. For generations, fathers possessed an absolute, uncontested right to custody, viewing children primarily as economic assets and laborers. A mother who left her husband had to accept the very real potential outcome of never seeing or speaking to her children again. We will trace how the late 19th century introduced the tender years doctrine, shifting historical trends toward maternal custody for young children, and how this legal evolution can be leveraged to create complex, agonizing choices for fictional characters. Ultimately, this masterclass solves the problem of narrative flatlining in historical fiction. It equips you with the step-by-step historical context needed to construct plots where the stakes are terrifyingly real, the character motivations are historically justified, and the potential outcomes reflect the true legal and cultural obstacles of the past. By honoring the actual constraints of the era, you elevate a standard historical romance or drama into a powerful commentary on human resilience, capturing the true cost of liberty in an era that denied it to so many. Turn to Part 2. To truly understand how deep the narrative rabbit hole goes, we must dismantle the foundational illusion that marriage in early America was a singular, uniform institution. It was not. If you are tracking historical trends across the 17th and 18th centuries, geography was destiny. Imagine a character named Abigail living in colonial Massachusetts in the year 1750. Abigail discovers her husband has committed flagrant adultery and has abandoned their farm to live with another woman in a neighboring town. Under the Puritan legal framework of the New England colonies, marriage was fundamentally viewed as a civil contract rather than a sacramental bond. Because it was a contract, it could be broken if one party violated its core terms. Abigail could petition the governor and the governor's council for an absolute divorce, a divorce of vinculo matrimoniae, which would completely dissolve the marriage and legally permit her to remarry. Historical trends in New England records show that while it was still incredibly difficult and required substantial proof, hundreds of women successfully petitioned for and received absolute divorces during the colonial era. Now, change the geography completely. Imagine that exact same character, Abigail, but place her in colonial Virginia or South Carolina in that exact same year of 1750. Her husband commits the exact same acts of adultery and desertion. What are her legal options? Absolutely zero. The southern colonies, deeply tied to the Church of England and English ecclesiastical law, did not establish any divorce courts, nor did they grant colonial legislatures the authority to dissolve marriages. In the eyes of the law in the colonial South, marriage was an indissoluble sacramental union. Abigail could not get an absolute divorce. She could not remarry. If she tried to move on with her life and enter a relationship with another man, any children born from that union would be legally classified as illegitimate, and she could be prosecuted for bigamy or lewd behavior. Her only possible legal recourse was a divorce mensa et thura, which translates to a divorce from bed and board. This was not a dissolution of the marriage. It was merely a legally sanctioned separation. It allowed Abigail to live apart from her husband without being forced by the law to return to his home, but the marital bond remained entirely intact. She was stuck in a legal purgatory, bound to a man who had abandoned her, unable to ever truly start over. This profound regional divide creates an instant goldmine for dramatic tension and plot development in historical fiction, yet contemporary narratives almost completely ignore it. Case studies of early American legal records demonstrate that characters would actively exploit these geographical disparities, creating the earliest iterations of migratory divorce. If a wealthy individual had the financial means and the freedom to travel, they would deliberately uproot their lives and move to a different jurisdiction, just to access more lenient divorce laws. This historical reality introduces a highly compelling, step-by-step narrative sequence that writers can use to inject authentic conflict into their stories. Let us map out this journey through a concrete scenario. Imagine a wealthy merchant named Samuel living in New York in the early 19th century. Samuel wants to dissolve his marriage, but New York has some of the strictest divorce laws in the country, recognizing only one single ground for absolute divorce: proven adultery. If Samuel cannot prove adultery, or if he refuses to subject his family to the public shame of an adultery trial, he faces a legal dead end in his home state. To bypass this structural wall, Samuel must execute a meticulous multi-stage strategy. First, he must liquidate a portion of his assets to fund an extended journey. Second, he must travel to a state like Indiana or Connecticut, which were gaining reputations in the mid-19th century as divorce mills due to their highly permissive omnibus clauses. These clauses allowed judges to grant divorces for broad, poorly defined reasons, such as any cause that the court deemed reasonable and proper. Once Samuel arrives in Indiana, the clock starts ticking on his residency requirement. He cannot just walk into a courthouse and file papers. He must establish a bona fide domicile. This means renting a house, opening a local bank account, registering to vote, and ensuring that prominent members of the local community see him every single day so they can later testify to his continuous residency. This process took anywhere from 3 months to a year depending on the specific state and the year. For a character in a novel, this residency period is a pressure cooker of narrative potential. They are living a double life in a strange town, constantly terrified that a private investigator hired by their spouse back home will discover their scheme and file an injunction to halt the proceedings. They are burning through their financial resources, watching their savings dwindle week by week, knowing that if they fail to meet the strict evidentiary standards of the local judge, the entire operation will collapse, leaving them financially ruined and still legally bound to their spouse. When we look at the potential outcomes of these historical trends, the stakes become even higher when viewed through the lens of gender and economic class. For a wealthy man like Samuel, a migratory divorce was a costly inconvenience. For a woman, it was an almost insurmountable hurdle. A married woman under coverture could not easily establish a separate legal domicile from her husband because, in the eyes of the law, her domicile was wherever her husband resided. If she fled to another state to seek a divorce, her husband could argue in court that she had committed the legal fault of desertion, completely invalidating her divorce petition and turning her into the guilty party. This brings us to the brutal reality of the fault-based divorce system that dominated the 19th century American landscape. In the modern era, we take no-fault divorce for granted, where a couple can simply state that their marriage has broken down irretrievably. In the 19th century, the legal system operated on a strict binary of innocence and guilt. To obtain a divorce, there had to be an innocent injured party and a guilty wrongdoing party. If both parties wanted the divorce and agreed to split, the law viewed this not as a mutual agreement, but as a fraudulent conspiracy against the state, known as collusion. If a judge suspected that a husband and wife had mutually agreed to divorce, he was legally obligated to dismiss the case immediately. This created an incredibly twisted dynamic where couples had to engage in elaborate, high-stakes legal theater, feigning bitter hostility in the courtroom while praying the judge would believe their performance. But what happened if both parties actually were guilty of marital misconduct? This introduces the legal doctrine of recrimination, one of the most devastating and dramatic legal hurdles of the era. If a wife sued her husband for divorce on the grounds of extreme physical cruelty, and the husband's lawyer managed to prove that the wife had once committed adultery, the judge would invoke recrimination. The legal philosophy was that a person coming to a court of equity must come with clean hands. If both spouses were found to be at fault, the court would refuse to grant a divorce to either of them. The potential outcome of a recrimination ruling was that the court would force two people who openly hated, abused, or betrayed each other to remain legally married forever, binding them together as a punishment for their mutual sins. Imagine the psychological horror of that scenario playing out in a narrative. A character fights for months, endures the public exposure of their deepest domestic traumas in a crowded courtroom, only to have the judge rule that because they were not completely blameless, they must return to the domestic cage. This historical reality blows the standard, clean historical fiction divorce arc completely out of the water. It forces characters to navigate a minefield where a single misstep, a single past mistake, or a single collusive agreement can destroy their chances of freedom forever. As we look deeper into the structural mechanics of these historical legal battles, we encounter an even more terrifying weapon used to maintain the marital status quo, one that targeted a character's very survival: the complete economic and social erasure of the divorced woman. If a woman somehow managed to navigate the regional divides, survive the residency requirements of a migratory divorce, and avoid the trap of recrimination to successfully prove her husband's fault, her battle was still only half won. She now had to face the catastrophic reality of what it meant to be a divorced woman in a society that offered no safety nets, no career paths, and absolute social ostracization. How did a woman feed herself when society branded her a fallen woman? How did she protect her children when the law viewed them as the sole property of her abusive ex-husband? The answers to these questions reveal the darkest, most compelling layer of the historical divorce journey: a layer where the true cost of freedom is measured not in courtroom fees, but in human devastation. Turn to Part 3 to uncover the shocking financial and custody traps that turned a legal victory into a living nightmare. To understand the sheer magnitude of the financial and custody traps awaiting a 19th-century woman, we must look past the courtroom doors and examine the grim reality of the day after a divorce was granted. Imagine a character named Eleanor living in Philadelphia in the year 1860. Eleanor has achieved what most women of her era thought impossible. She successfully sued her husband for divorce on the grounds of extreme physical cruelty. She stands on the steps of the courthouse, a free woman in the eyes of the law. But as she reaches into her reticule, she realizes she possesses exactly $0. Under the prevailing legal structures of the time, even if Eleanor had brought a massive dowry of family money, real estate, and personal property into the marriage, all of it legally belonged to her husband the moment they uttered their vows under the rules of coverture. When a marriage dissolved due to fault, the distribution of property was not an equitable 50-50 split. Historical trends indicate that courts routinely strip the guilty party of property, but if a woman was the innocent plaintiff, her access to financial support, known as alimony, was entirely at the discretion of a male judge who likely believed that a woman's natural place was under the protection of a man. If the judge granted her alimony, it was rarely enough to live on independently. More importantly, enforcing an alimony order was an absolute nightmare. There were no state agencies to automatically garnish wages, no centralized tracking systems, and no modern enforcement mechanisms. If Eleanor's ex-husband simply refused to pay, or if he packed his bags and moved across state lines to New York or Ohio, her alimony vanished instantly. To get it back, Eleanor would have to hire another lawyer, file a new non-compliance suit, and pay court fees she could not afford, all while starving in the interim. This economic castration meant that an innocent, divorced woman faced a terrifyingly narrow set of potential outcomes for survival. Society in 1860 offered virtually no respectable employment opportunities for middle or upper-class women. Eleanor could not simply walk into a corporate office and get a job. She was limited to low-wage, highly exploitative labor, working as a seamstress, a governess, a schoolteacher, or a live-in domestic servant. The moment she entered these workforces, her social standing evaporated. In the eyes of Gilded Age and Victorian society, a divorced woman was viewed with profound suspicion. She was treated as a cultural pariah, a dangerous destabilizing force who had failed in her primary structural purpose, maintaining a stable domestic hearth. Hostesses would cross her off their guest lists, former friends would cross the street to avoid speaking to her, and landlords would refuse to rent apartments to her, assuming her presence would corrupt the moral fabric of the neighborhood. But the financial trap was nothing compared to the absolute weapon used by husbands to crush a wife's rebellion: the total legally sanctioned theft of her children. Case studies from the first half of the 19th century reveal a custody landscape that sounds downright dystopian to a modern audience. Under English common law, which heavily dictated American jurisprudence, a father possessed an absolute, paternal right to the custody of his legitimate children. Children were not viewed through the modern lens of emotional development or psychological well-being. They were viewed as economic assets. Children provided valuable agricultural labor on farms or earned wages in early factories, and a father had a legal right to those economic fruits. Furthermore, the law argued that because the father was the sole property owner and wage earner under coverture, only he possessed the financial means to maintain, educate, and support the children. Let us map out a harrowing step-by-step scenario to illustrate how this played out in real life. Imagine Eleanor has 2 children, a 5-year-old son and a 3-year-old daughter. During her marriage, her husband was openly abusive, squandering their money in gambling dens and bringing physical violence into the home. Desperate to save her children from this toxic environment, Eleanor flees the house in the dead of night, taking the children with her to her brother's home. The very next morning, her husband does not file for divorce. Instead, he obtains a writ of habeas corpus against Eleanor's brother, demanding the immediate return of his property, his children. When they appear in court, Eleanor begs the judge to look at the bruises on her arms. She provides testimonies from neighbors who heard her screams. But under the strict legal precedents of the early to mid-19th century, the judge would rule that a mother had no legal right to separate children from their father, unless it could be proven that the father was actively teaching the children to commit capital crimes, or was completely incapable of providing basic sustenance. The father's cruelty to his wife was legally irrelevant to his fitness as a father. The judge would order the bailiffs to physically tear the weeping children from Eleanor's arms, and hand them over to the abuser. Once the father had custody, he held absolute power. He could legally forbid Eleanor from ever seeing, visiting, or writing to her children again. If Eleanor persisted in trying to see them, she could be arrested for trespassing or harassment. To make matters worse, a vengeful husband could legally farm the children out to relatives in a distant state, or place them in a strict boarding school under an assumed name, completely erasing them from Eleanor's life. This was the ultimate chess move. Hundreds of thousands of historical women chose to endure horrific domestic abuse, systemic infidelity, and psychological torture for decades, deliberately sacrificing their own safety and sanity, simply because they knew that the potential outcome of leaving was the permanent, legal loss of their children. As historical trends progressed into the mid to late 19th century, a legal shift began to emerge, known as the tender years doctrine. This doctrine, influenced by the rising cultural cult of true womanhood, argued that very young children, particularly infants and toddlers, required the unique emotional, nurturing care of a mother for their proper moral and physical development. While this sounds like a massive victory for women, in practice, it created a whole new set of complex legal and narrative hurdles. The tender years doctrine did not grant mothers an automatic right to custody, it merely gave them a rebuttable presumption. A husband's legal team could easily dismantle this presumption by attacking the mother's moral character in court. If a woman sought custody under the tender years doctrine, her entire private life was put under a legal microscope. If her husband could present a single intercepted letter suggesting she had a platonic male friend, or if a disgruntled maid testified that the wife enjoyed reading secular novels or missed Sunday church services, the court would brand her an unfit mother. The double standard was absolute. A husband could openly visit brothels and retain custody because his public economic stability remained intact, but a wife had to maintain flawless, saintly purity just to be considered for custody of her own toddler. And even if she won custody under the tender years doctrine, it was a temporary truce. The moment the child reached the age of 7 or 8, the tender years period expired, and the legal right to custody reverted right back to the father, allowing him to claim the child just as they became old enough to be useful or companionable. This psychological and legal warfare turns every single step of the historical divorce journey into a high-stakes chess match where the characters are playing for keeps. When historical fiction bypasses these realities, it completely misses the profound heroism of the women who actually fought these battles. They weren't just signing papers. They were fighting a total war against a legal system designed to erase them from existence. Turn to Part 4 to discover how the rise of the scandalous legislative divorce turned private marital misery into an explosive public political circus that rocked the highest echelons of American power. Before the judicial system took complete control over marital dissolution in the United States, there existed an even more bizarre, exclusive, and deeply political mechanism for ending a marriage: the legislative divorce. To understand how this completely upends the conventional narratives of historical fiction, we have to look back at the late 18th and early 19th centuries. Imagine a wealthy elite landowner named Harrison living in Virginia in the year 1810. Harrison wants to dissolve his marriage to his wife, Clara. Because Virginia has no divorce courts and recognizes no judicial process for absolute divorce at this time, Harrison cannot simply file a lawsuit. Instead, he must execute an intensely public, multi-stage political campaign. He must draft a personal petition, travel to the state capitol, and convince a sitting member of the state legislature to introduce a private bill on his behalf, effectively asking the entire state government to pass a custom law just to dissolve his individual marriage. This process turned a deeply private family tragedy into a matter of public debate and political ledger balancing. Legislative records from this era reveal that a private bill of divorce had to go through the exact same rigorous legislative process as a bill to build a state highway or charter a bank. The petition would be read aloud on the floor of the legislature, referred to a specific committee, debated by politicians who had absolutely no training in family law, voted on by both houses, and finally sent to the governor's desk for a signature. For a character in a novel, this means that their deepest domestic secrets, their financial disputes, and allegations of betrayal were printed in public legislative journals and read aloud to roomfuls of politicians. Case studies of early 19th century legislative divorces show that this mechanism was almost entirely a game of political patronage, immense wealth, and social influence. If Harrison was a powerful political donor or a member of an influential family, his bill might sail through the committee with minimal scrutiny. But if his wife Clara belonged to a rival political faction, her family could lobby members of the legislature to block the bill. turning their private marital breakdown into an explosive proxy war between political parties. The potential outcomes of these votes depended far more on backroom political deals, log-rolling, and favors than on the actual merits or evidence of the case. A politician might vote to grant Harrison his divorce not because he believed Harrison's claims, but because Harrison's cousin promised to vote in favor of a new canal project in that politician's district. This absolute reliance on elite networks meant that for the average American citizen, a legislative divorce was an impossible luxury. It required the financial resources to hire capital city lobbyists, print public notices in local newspapers for weeks in advance to alert the spouse, and cover the massive administrative fees associated with private bills. If an ordinary blacksmith or an impoverished frontier farmer found themselves in a broken marriage, the legislative path was entirely closed to them. This creates a massive structural divergence in historical trends. The wealthy could occasionally buy their way out of a marriage through political maneuvering, while the working class was forced into permanent, extra-legal separation, often leading to informal bigamy or desertion, commonly referred to as the poor man's divorce. As the 19th century progressed, the sheer volume of these private divorce petitions began to completely paralyze state legislatures. State representatives were spending weeks debating the sordid details of broken marriages instead of governing. This led to a massive constitutional shift across the United States. One by one, states began rewriting their constitutions to explicitly ban legislative divorces, transferring the authority entirely to the judicial court system. While this shift was intended to streamline the process and democratize access to divorce, it actually created a brand new, highly visible arena for public scandal: the local courthouse. When the judicial system took over, it brought with it the strict requirement of public trials and the open recording of evidence. Imagine if a modern celebrity scandal was played out not on social media, but in a small crowded local courtroom where local newspaper reporters sat in the front row, transcribing every single word of testimony shorthand to print in the next morning's edition. This was the reality of the 19th century fault-based judicial divorce. Because a plaintiff had to prove absolute statutory fault, such as extreme cruelty or adultery, the courtroom became a theater of raw human misery. Let us look at a step-by-step breakdown of how a public judicial divorce trial could completely weaponize social standing. Imagine a prominent family name in New York, where the wife, Charlotte, sues her husband for adultery. To secure the divorce under New York's strict laws, Charlotte cannot just show a suspicious letter. She must present concrete, undeniable proof of physical infidelity. This meant her legal team had to hire early private investigators, known then as shadows or secret agents, to follow her husband into brothels, boarding houses, or private apartments. These investigators, along with carriage drivers, hotel maids, and disgruntled house servants, would be called to the witness stand to testify in graphic detail about what they saw through keyholes, the condition of the bedsheets, and the state of undress of the defendants. The public impact of this testimony was devastating. The courtroom galleries were often packed to maximum capacity with local citizens who attended these trials as a form of free, live entertainment. For a character of high social standing, this public exposure was a fate worse than death. Every detail of their private health, their emotional breakdowns, and their domestic arguments was laid bare for the entire community to consume. Newspapers did not merely report the verdict. They printed full, sensationalized transcripts of the cross-examinations, complete with salacious headlines, transforming a private legal matter into a permanent public stigma. This extreme public shaming created a profound counter-strategy that historical fiction rarely explores: the weaponization of countersuits and blackmail. If a husband knew his wife was planning to sue him for cruelty, he would immediately threaten to countersuit her for a fault that carried far greater social destruction, such as habitual drunkenness or madness. By threatening to drag her reputation through the public mud, a spouse could effectively force the other into submission, trapping them in the marriage through the sheer terror of public exposure. The transition from the political circus of the legislature to the public theater of the judicial court completely altered the strategic landscape for anyone seeking freedom. It meant that even if a character possessed the legal grounds, the financial resources, and the personal fortitude to seek a divorce, they had to be willing to completely incinerate their social standing and sacrifice their family's privacy on a public stage. The potential outcomes were no longer just about legal status. They were about total social survival in a world that remembered every headline. But as the classical judicial system grew more rigid and oppressive, a few enterprising territories and states noticed a massive economic opportunity in this domestic despair. They realized that by manipulating residency laws and expanding legal grounds, they could attract wealthy, desperate individuals from all over the country, turning marital dissolution into a highly lucrative local industry. This sets the stage for one of the most wild, volatile, and culturally shocking phenomena in American history. Turn to Part 5 to discover the rise of the radical Western frontier divorce colonies, where the rules of society were completely rewritten, and a new breed of legal entrepreneurs turned a remote territory into the scandalous divorce capital of the world. As the strict, fault-based judicial system tightened its stranglehold on eastern states, the vast expanse of the western frontier emerged as a radical, disruptive laboratory for American matrimonial law. To understand the sheer magnitude of this cultural and legal shockwave, we have to look closely at the late 19th century, specifically focusing on the remote territory of Dakota. Imagine a wealthy, socially prominent woman named Gertrude living in Boston in the year 1890. Gertrude is trapped in an emotionally dead marriage, but Massachusetts law offers her absolutely no path to freedom unless she can prove physical violence or desertion. Desperate for an escape, Gertrude boards a transcontinental train, leaving behind her high society life, and travels thousands of miles west to the small, bustling town of Sioux Falls, South Dakota. Gertrude is not embarking on a rugged frontier adventure. She is participating in a highly organized, legally streamlined phenomenon known as the Western Divorce Colony. In the 1890s, South Dakota recognized a massive economic opportunity in the domestic gridlock of the East. While eastern states required years of separation and ironclad proof of severe marital crimes, South Dakota law required a residency period of a mere 90 days. Furthermore, their statutes included incredibly broad, loosely defined grounds for divorce, such as cruelty, which local frontier judges routinely interpreted to include emotional distress, neglect, or merely compatibility issues. For a character like Gertrude, arriving in Sioux Falls initiated a highly specific, step-by-step institutional process managed by a new breed of legal entrepreneurs. The moment her train pulled into the station, she was met not by cowboys, but by specialized divorce lawyers who had set up lucrative practices catering exclusively to wealthy Easterners. These lawyers would instantly check Gertrude into a luxury hotel or a specialized boarding house designed specifically to house the influx of affluent plaintiffs. To satisfy the 90-day residency requirement, Gertrude had to engage in a calculated performance of permanent habitation. She had to open a local bank account, hire local servants, lease property, and make sure she was seen walking down Main Street every single day by prominent townspeople who could later serve as her residency witnesses in court. This setup created an unprecedented, surreal parallel society within these frontier towns. Historical trends from the era show that at any given moment, hundreds of wealthy Eastern elites, mostly women, were living side by side in Sioux Falls boarding houses, waiting out their 90-day clocks. They formed their own tight-knit social circles, attending dinners, picnics, and theater performances together, united by their shared pursuit of marital freedom. The local economy completely adapted to serve this temporary population. High-end boutiques, luxury restaurants, and specialized legal offices flourished, turning a remote prairie outpost into a cosmopolitan hub funded entirely by the business of marital dissolution. But the potential outcomes of this frontier escape route were fraught with profound legal instability and high-stakes conflict. The sudden rise of the Dakota divorce colonies triggered an immediate, furious backlash from conservative Eastern judiciaries, religious institutions, and traditional media outlets. Eastern newspapers ran sensationalized exposes, branding Sioux Falls a moral plague spot and labeling the women who went there as dangerous, home-wrecking radicals. This backlash created a terrifying legal trap for a character returning home with a Western decree. Imagine Gertrude completing her 90 days, securing her absolute divorce from a sympathetic South Dakota judge, and triumphantly returning to Boston. She believes she is a free woman. She might even use her new freedom to remarry a new partner. However, her original husband back in Massachusetts has no intention of letting her go so easily. He files a lawsuit in a Massachusetts court, claiming that Gertrude's South Dakota residency was an absolute sham, a fraudulent evasion of Massachusetts law designed solely to bypass their strict statutory limitations. Under the prevailing constitutional debates of the late 19th century, the United States legal system faced a massive crisis regarding the full faith and credit clause of the Constitution, which dictates that states must recognize the public acts, records, and judicial proceedings of every other state. Eastern judges, furious at the West for undermining their domestic policies, began routinely ruling that if a person moved to another state temporarily for the sole purpose of obtaining a divorce, the home state was under no legal obligation to recognize that decree. The potential outcome for Gertrude was catastrophic. The Massachusetts court would declare her South Dakota divorce completely null and void. In the eyes of her home state, she was still legally married to her first husband. This meant her new marriage was legally classified as bigamous. Any children born from her new union were legally branded as illegitimate, and her first husband still retained full, legal control over any property she possessed within Massachusetts. This legal gridlock turns the post-divorce narrative into a psychological thriller. A character could possess a valid legal document in one pocket and a warrant for bigamy in the other, depending entirely on which side of a state line they happen to be standing on. Case studies from this era demonstrate that this interstate legal warfare reached the absolute highest echelons of American jurisprudence, culminating in landmark Supreme Court cases that attempted to resolve the chaos of migratory divorce. The Western frontier did not just offer an easy way out. It created a fragmented legal minefield where a single character's freedom could be wiped out by a change in state judicial interpretation. This reality completely explodes the naive historical fiction trope of a clean, uncontested Western escape. It injects a constant, lingering threat of legal re-enslavement that follows a character long after they leave the frontier. The rise of the divorce colonies also forced a massive generational shift in how the public viewed the permanence of marriage, setting off a nationwide culture war that lasted well into the 20th century. Traditionalists realized that as long as individual states possessed the sovereign right to write their own domestic laws, the strict lifelong definition of marriage was fundamentally dead. They began a massive, multi-decade political campaign to establish a uniform federal divorce law across the entire United States, aiming to strip individual states of their permissive statutes and close the Western loopholes forever. This political battle line creates an incredible backdrop for historical narratives, pitting progressive legal reformers, early feminists, and Western entrepreneurs against traditionalist politicians, conservative judges, and powerful religious coalitions. Characters navigating this era are caught in the crosshairs of a macro-level struggle over the very definition of American family life. Every individual petition filed in a Western courthouse was a shot fired in a larger war over bodily autonomy, economic independence, and the limits of state sovereignty. As the calendar turned toward the 20th century, this culture war took an even sharper, more modern turn. The closing of the Western frontier and the eventual tightening of South Dakota's residency laws did not stop the demand for marital freedom. It merely shifted the geographic center of gravity. The legal entrepreneurs of the 20th century took the blueprint created by the frontier colonies and supercharged it, creating an even faster, more streamlined, and internationally famous capital of dissolution. Turn to Part 6 to discover the mechanical inner workings of the early 20th century Nevada divorce machine, where Reno became a global household name, and a new wave of characters risked everything to experience the high-speed assembly line of modern marital liberation. When the Dakota loophole officially closed in the early 20th century due to rising political pressure and extended residency requirements, the state of Nevada stepped into the vacuum, constructing a massive, highly efficient assembly line for marital dissolution that would dominate the American cultural and legal landscape for decades. To truly grasp the narrative goldmine of this era, we must look at how Reno, Nevada, transformed from a sleepy railroad town into the undisputed divorce capital of the world. Imagine a stylish, upper-class woman named Vivian living in Chicago in the year 1930. Vivian is desperate to escape a toxic marriage, but Illinois law remains rigidly restrictive. Instead of engaging in a years-long, public, and reputation-destroying legal battle in Chicago, Vivian boards the Overland Limited train and heads straight for Reno. What awaited Vivian in Reno was not a secretive, shameful ordeal, but a highly commercialized, thoroughly institutionalized lifestyle industry. In 1927, Nevada had lowered its residency requirement to a mere 3 months, and by 1931, in the depths of the Great Depression, the state slashed it even further to an astonishing 6 weeks in a desperate bid to generate local revenue. The step-by-step process for a character like Vivian was highly specific and strictly regulated by the state to protect the integrity of the local economy. Upon arrival, Vivian could not simply check into a hotel and hide away for 6 weeks. She had to establish a highly visible, legally verifiable domicile. For the ultra-wealthy, this meant checking into one of the specialized divorce ranches that sprang up around the Sierra Nevada mountains. These ranches were a fascinating cultural phenomenon. They operated as high-end dude ranches where wealthy Easterners could spend their 6 weeks riding horses, playing tennis, swimming, and socializing with other elites going through the exact same emotional and legal transition. For the middle class, the process involved renting a room in a downtown Reno boarding house or checking into the famous Riverside Hotel right next to the Washoe County Courthouse. Regardless of income, the potential outcomes of the entire endeavor hinged on a single vital legal mechanism: the residency witness. Every day, Vivian had to ensure she was seen by her landlord, her ranch owner, or a local merchant. At the end of the 6 weeks, this local resident would literally step into the courtroom and swear under oath that they had seen the plaintiff in the county every single day without exception. This 6-week waiting period serves as a magnificent pressure cooker for historical narrative conflict. A character is stranded in a high-desert liminal space, caught between their past life and an uncertain future. Case studies from the era show that Reno became a melting pot of psychological tension. You had socialites rubbing elbows with working-class women, all bound by a shared secret purpose. The town itself thrived on this influx of wealth. Guests spent money on housing, fine dining, gambling, and high-end retail, pumping millions of dollars into the Nevada economy when the rest of the nation was economically paralyzed. But do not let the glamorous veneer of the Reno divorce ranch fool you. The actual legal proceedings inside the Washoe County Courthouse were a swift, cold, and calculated assembly line. Once the 6 weeks expired, Vivian's lawyer would file the petition under the broad, elastic category of mental cruelty. The actual trial rarely lasted more than 10 or 15 minutes. The judge would ask a few standardized questions, the residency witness would provide their testimony, and with the strike of a gavel, the marriage was dissolved. There was a famous local tradition where newly divorced individuals would walk straight out of the courthouse steps to the nearby Virginia Street Bridge and cast their wedding rings into the rushing waters of the Truckee River, symbolizing their absolute liberation. Yet, just like the Dakota system before it, the potential outcomes of a Reno divorce back in the plaintiff's home state were a minefield of constitutional crises and retaliatory litigation. If Vivian's husband back in Chicago refused to recognize the Nevada decree, he could countersue her for desertion or bigamy the moment she set foot back in Illinois. The legal system was plagued by the concept of divisible divorce, meaning a Nevada court could successfully dissolve the marital status, but it had no legal jurisdiction to award alimony, divide out-of-state property, or enforce child custody if the husband had refused to legally appear or be represented in the Nevada court. This meant that while Vivian might be a free woman in Reno, her financial survival back home remained entirely unsecured. If she had left her children behind in Chicago to complete her 6-week residency, her husband could use her temporary absence to permanently strip her of her maternal custody rights, branding her an unstable, runaway mother in an Illinois court. The Reno journey was a high-stakes gamble where characters frequently had to trade their financial security and their proximity to their children for the raw, legal right to own their own identity. Historical trends during the mid-20th century show that this tension reached a boiling point during World War II and its immediate aftermath. The rapid disruption of wartime marriages, hasty departures, and shifting social morals caused the Reno divorce rate to skyrocket to unprecedented heights. It became a global cultural obsession, featured in Hollywood movies, literature, and sensational news columns. This public infatuation forced traditional jurisdictions to double down on their hostility toward migratory decrees, creating a fractured legal landscape where a character's marital status could literally change as they crossed state lines on a train ride home. The Reno machine represents the absolute pinnacle of the commercialization of marital freedom in American history. It proved that when the law creates artificial barriers to human liberty, an entire parallel economic system will rise to exploit and alleviate that pressure. It turned the deeply private, traumatic ending of a family unit into a highly structured, state-sanctioned vacation, completely transforming the cultural conversation surrounding divorce from an unspeakable social death into a modern, almost chic rite of passage. But as the mid-20th century progressed, this reliance on migratory escape valves began to look increasingly obsolete to a new generation of legal reformers, civil rights activists, and ordinary citizens. People began to ask a fundamental question. Why should an American citizen have to flee their home state, spend thousands of dollars, and live a lie in the desert for 6 weeks just to access a basic human right? The pressure was mounting not just to find cracks in the wall, but to tear the entire wall down from within. Turn to Part 7 to discover the explosive internal legal revolution that finally shattered the old fault-based system. As we examine the clandestine world of migratory divorce alternatives, and the rise of the scandalous institutionalized perjury mills that operated right in the heart of America's biggest cities. To truly appreciate the internal rot of the mid-20th century American matrimonial system, we must pivot away from the dusty trails of the West and look directly into the urban landscapes of the East, where citizens who could not afford a 6-week trip to Reno were forced to engage in institutionalized, systemic fraud just to secure their freedom. The epicenter of this legal hypocrisy was New York State. From the late 19th century all the way until 1966, New York obstinately maintained an incredibly archaic statutory framework, recognizing only one single ground for absolute divorce: proven adultery. This legislative rigidity did not stop people from wanting to end their marriages. Instead, it created a massive underground economy of institutionalized perjury, collusion, and staged scandals that operated right under the noses of corrupt or deliberately indifferent judges. Imagine a middle-class couple, Arthur and Beatrice, living in Manhattan in the year 1948. Their marriage has completely disintegrated over years of emotional neglect, and they both mutually desire to separate and move on with their lives. However, because they cannot afford the travel expenses, lodging, and out-of-state attorney fees required for a migratory Reno divorce, they must navigate New York's restrictive legal system. Because they are honest people, neither has actually committed adultery, but the law demands a guilty party and a specific marital crime. To break this legal deadlock, Arthur and Beatrice must step-by-step contract the services of a highly specialized underground legal industry, the New York divorce mill. The execution of this staged scandal was a cold, calculated business transaction. Arthur's attorney would hire a private detective agency that kept professional correspondents on their payroll. These correspondents were typically young, low-income women who were paid a flat fee to act as the other woman in a carefully choreographed piece of legal theater. On a designated weekend, Arthur and the hired correspondents would check into a Midtown Manhattan hotel under their real names. They would enter the hotel room, unpack a bag to make the room look occupied, and then wait. A few hours later, right on cue, a team of private investigators hired by Beatrice's attorney, accompanied by a strategic witness, such as a mutual friend or a relative, would march up to the hotel room door and loudly demand entry. The door would open, and the investigators would burst into the room with flashbulb cameras. Arthur would be photographed standing in his undershirt or a silk bathrobe, while the hired correspondent would be sitting on the edge of the bed, perhaps holding a sheet up to her chin to simulate a state of undress. No actual sexual intimacy occurred, and no laws were broken beyond the massive fraud being perpetrated against the court. The next morning, these photographs, along with the sworn eyewitness testimonies of the private investigators, would be presented in a New York courtroom as ironclad, undeniable proof of Arthur's flagrant infidelity. Historical trends from this era indicate that judges, lawyers, and court clerks were fully aware that these scenes were completely fabricated. Yet, because the paperwork looked flawless and the required evidentiary checkboxes were filled, the judges would routinely grant the divorce, maintaining the public illusion of moral purity, while actively participating in a system of institutionalized perjury. For a character in historical fiction, this underground process introduces immense narrative tension and high-stakes vulnerability. The entire strategy depended on absolute secrecy and perfect execution. If Arthur or Beatrice had a sudden change of heart, or if a disgruntled private detective demanded more money and threatened to expose the collusion to the district attorney, the potential outcomes were catastrophic. Collusion was a serious crime, and if a judge officially discovered that the adultery was staged, the divorce petition would be dismissed with prejudice, the lawyers could be disbarred, and the spouses could face criminal indictments for perjury and conspiracy. Furthermore, this reliance on staged sin took a massive psychological toll on the character designated as the guilty party. Even though the inner circle knew the hotel raid was a farce, the public court records were entirely permanent. Arthur would be legally branded an adulterer, a public designation that could destroy his professional career, get him expelled from his social clubs, and permanently damage his relationships with his extended family and children, who might grow up believing the public lies printed in the legal notices. Case studies from the 1940s and 1950s reveal that this system of manufacturing evidence became so widespread and flagrant that it eventually triggered massive media exposes and grand jury investigations. Investigators uncovered rings of professional correspondents who testified in dozens of different divorce cases a year, changing their hair color and using aliases to deceive different judges. The hypocrisy of the law had turned the entire judicial apparatus into a laughingstock, forcing ordinary, law-abiding citizens to drag their dignity through the mud just to escape the legal bonds of matrimony. While the wealthy flew to Reno and the urban middle class manufactured hotel raids, working-class Americans who could afford neither option were left with the most dangerous alternative of all: absolute abandonment and informal bigamy. If a character lacked the resources to engage the legal machine, they would simply pack a suitcase, walk out the door, and disappear into the vast geography of the United States, leaving their spouse in a state of permanent legal limbo, unable to access any financial support or ever legally remarry. This absolute polarization of access to marital freedom created a profound crisis within American society, turning marriage law into a weapon of class privilege and structural oppression. The massive disconnect between the rigid, moralistic statutes on the books and the corrupt, deceptive realities of the courtroom could not hold indefinitely. The pressure cooker of the mid-20th century was reaching a critical tipping point, driven by the social upheavals of the civil rights movement, the rising tide of second-wave feminism, and a new generation of legal scholars who demanded that the law reflect the true, unvarnished reality of human relationships. The stage was set for an absolute, systemic overhaul that would completely dismantle centuries of common law tradition, sweep away the fault-based system entirely, and permanently redefine the relationship between the citizen, the family, and the state. Turn to Part 8 to witness the explosive dawn of the modern legal revolution, as we examine the fierce legislative battles of the 1960s, the introduction of true no-fault divorce, and the radical re-engineering of American family life that changed the rules of storytelling forever. The structural rot of the perjury mills and the blatant regional hypocrisy could only hold the American legal apparatus captive for so long before a complete systemic collapse became inevitable. To fully comprehend how the rules of historical fiction storytelling are fundamentally rewritten in the mid-20th century, we must analyze the explosive dawn of the modern legal revolution. Imagine a character named Frank, a middle-class engineer living in Sacramento, California, in the year 1969. Frank and his wife Evelyn have watched their marriage slowly erode into absolute coldness over 15 years. There is no physical violence, no dramatic hotel room adultery, and no desertion. Under the long-standing traditional law, they are trapped. But the year 1969 represents ground zero for a legislative earthquake. Governor Ronald Reagan signs the Family Law Act of 1969, making California the very first state in the nation to systematically eliminate the concept of fault from the dissolution of marriage. This introduced true no-fault divorce, a radical legal re-engineering that completely swept away centuries of common law heritage. No longer did Frank or Evelyn have to assume the public role of the wrongdoer or the victim. The state introduced a singular, revolutionary legal ground, irreconcilable differences which have caused the irremediable breakdown of the marriage. The step-by-step impact of this legislative shift on a narrative cannot be overstated. It completely altered the mechanics of plot progression, moving the central conflict away from the collection of sordid evidence and redirecting it toward the cold, hard mathematics of asset distribution and long-term financial restructuring. Case studies tracking historical trends throughout the early 1970s reveal that once the no-fault floodgates opened, the national landscape experienced an immediate, unprecedented surge in filings. This was not because happily married people suddenly decided to split. Rather, it was because decades of buried domestic misery, previously held in check by the terrifying hurdles of the fault-based system, were finally granted a legitimate legal exit. For a historical fiction writer tracking characters across this specific transitional era, the dramatic tension shifts entirely. The fear of public exposure in a sensationalized trial evaporates, replaced by a hyper-focused, administrative battle over the material terms of separation. Let us map out the step-by-step transformation of this new legal reality. In a traditional fault-based system, proving a spouse's guilt gave the innocent party immense leverage over property and custody negotiations. If a wife could prove her husband was a chronic adulterer, the judge would routinely punish him financially, awarding her a larger share of the marital assets and permanent alimony as a form of societal retribution. Under the new no-fault framework established in the 1970s, fault was stripped of its economic leverage. The law increasingly viewed marriage not as a moral covenant monitored by the state, but as an equal economic partnership, similar to a commercial business venture. When the partnership dissolved, the potential outcome shifted toward an equitable distribution of property, regardless of who fell out of love first. This introduced a new kind of psychological warfare into historical narratives. Imagine Evelyn, who has spent 20 years managing the household and sacrificing her own career prospects to support Frank's advancement, discovering that under the new no-fault rules, Frank can walk into a courthouse, unilaterally file for dissolution, and walk away with half the assets without ever having to justify his choice to a judge. The narrative conflict transforms from a battle against an oppressive state apparatus into an intimate, agonizing negotiation over systemic inequality, future self-sufficiency, and the sudden devaluation of domestic labor. This era also witnessed a profound, structural revolution in the financial protections afforded to women, running parallel to the no-fault transition. For generations, a married woman's financial identity was tethered to her husband. Even after the historical erosion of coverture, credit institutions and banking structures routinely denied independent financial agency to single or divorced women. Imagine if a divorced character in 1972 tried to rent an apartment, purchase a car, or secure a mortgage to rebuild her life, only to be told she could not do so without the signature of a male guarantor, such as her father, her brother, or ironically, her ex-husband. This financial blockade was formally dismantled by the Equal Credit Opportunity Act of 1974, a massive legislative milestone that prohibited discrimination based on sex or marital status in any credit transaction. This historical data point is a critical tool for contextualizing historical fiction. It means that prior to 1974, a character's post-divorce journey was fundamentally defined by systemic economic paralysis, whereas the late 1970s opened up a completely new realm of potential outcomes, allowing a character to establish authentic material independence for the very first time in American history. Simultaneously, the legal definition of child custody underwent a massive, contentious realignment. The traditional tender years doctrine, which had given mothers a distinct advantage in securing custody of young children during the late 19th and early 20th centuries, faced intense constitutional challenges. Reformers argued that the doctrine perpetrated outdated gender stereotypes, punishing women who entered the workforce and ignoring the parental rights of fathers. Courts began adopting the best interests of the child standard, a holistic, gender-neutral approach that evaluated which parent could provide the most stable, nurturing environment. This standard, while progressive, introduced a new layer of unpredictable narrative conflict. Because the best interest standard was highly subjective, child custody battles in the late 1970s and 1980s turned into battlegrounds of psychological evaluation, home inspections, and bitter character assassinations. A character could no longer rely on a maternal presumption. They had to actively prove their superior fitness on a daily basis, turning the domestic sphere into a scrutinized fishbowl where every parenting choice was dissected by court-appointed experts. The dawn of no-fault divorce and the restructuring of economic and custody laws completely shattered the old frameworks of American family life. It removed the state as the moral arbiter of love and commitment, placing the responsibility squarely on the individuals. For characters navigating this modern legal landscape, the enemy was no longer a rigid statutory wall or a corrupt perjury mill. The enemy was the cold, administrative efficiency of an equal partnership dissolution that forced them to confront the exact material value of their shared life. But as the legal system evolved to make exit strategies easier and more equitable within the borders of the United States, a profound and disturbing question began to echo through the cultural subconscious. What happens when the legal systems of the past, with all their institutional scars, property biases, and gender traps, continue to exert a powerful unconscious influence on how modern audiences interpret historical narratives? Why do contemporary creators continue to sanitize these brutal historical realities? And what do we lose when we replace authentic human struggle with anachronistic comfort? Turn to Part 9 to analyze the profound psychological disconnect between modern readers and historical truths, as we dissect the dangerous rise of retrofitted morality in contemporary historical fiction. To fully appreciate the narrative crisis facing contemporary historical fiction, we must analyze the profound psychological disconnect that occurs when modern creators retrofit 21st century morality onto characters navigating the rigid structures of the past. When a contemporary author writes a story set in the Regency era, the Gilded Age, or the Great Depression, they often find themselves caught in a complex creative dilemma. They want to appeal to a modern, progressive audience that values individual autonomy, personal empowerment, and gender equality. However, the actual historical trends of those eras present an incredibly bleak, hostile environment for those specific values. To solve this discomfort, creators frequently engage in a dangerous literary practice. They sanitize the past, erasing the true legal and economic traps to provide their characters with a smooth, anachronistic path to self-actualization. Imagine a contemporary novel published in the current year 2026, set in late 19th century Chicago. The protagonist, a woman named Margaret, decides to leave her husband simply because he does not support her artistic ambitions. In the novel, Margaret packs her bags, rents a charming apartment downtown, secures a divorce within 2 chapters, and lives happily ever after as an independent woman. While this narrative feels deeply satisfying to a modern reader consuming the story in 2026, it represents an absolute failure of historical contextualization. It completely erases the reality that in that specific era, a woman who walked out on her husband for such reasons would be legally classified as a deserting spouse, would automatically forfeit any right to her children, would be completely denied access to bank accounts under coverture traditions, and would face absolute social ruin. By removing these structural walls, contemporary narratives inadvertently minimize the profound bravery of the real historical figures who actually fought these battles. When a fictional character secures freedom effortlessly, it implies that the real women of the past who remained in unhappy or abusive marriages simply lacked the strength or the imagination to leave. It replaces a harrowing systemic struggle against the entire weight of the state with a lightweight, individualized choice. Case studies of authentic historical memoirs reveal a completely different reality. The individuals who actually pursued separation in the 18th and 19th centuries were not embarking on light-hearted journeys of self-discovery. They were desperate, radical survivors who understood that their potential outcomes included institutionalization, poverty, and the total loss of their children. Let us look closely at a step-by-step example of how this retrofitted morality actively damages the narrative stakes of a story. Imagine a writer creating a historical drama set in colonial Virginia. The writer wants the heroine to divorce her unfaithful husband to demonstrate her strength. If the writer retrofits modern values, the heroine simply files some papers, receives a sympathetic nod from a judge, and moves on with her life. The plot immediately loses all its engine power because there is no friction. Now, look at how that exact same story functions when you inject authentic historical context. The heroine discovers her husband's infidelity, but she realizes she lives in a jurisdiction that recognizes no judicial path to absolute divorce. Her husband controls every penny she has ever inherited, and if she flees, she can be hunted down by the law as a runaway property. Suddenly, her desire for freedom is no longer a simple lifestyle choice. It is a high-stakes, terrifyingly dangerous chess match against an entire empire. Every single action she takes requires strategic planning, immense sacrifice, and a willingness to operate in the shadows of society. She cannot just hire a lawyer. She has to manipulate elite networks of political patronage to even get a private bill introduced in the state legislature, knowing that a single misstep will expose her to public humiliation and permanent ruin. By honoring the actual brutal constraints of the era, the writer transforms a standard melodrama into a masterpiece of human resilience. The character's strength is proven not by how easily she breaks the rules, but by how masterfully she navigates a system that was specifically engineered to destroy her. This sanitization of historical trends also distorts the public's understanding of legal history, creating an illusion that progress was a linear, uninterrupted march toward enlightenment. In reality, the evolution of American matrimonial law was a violent, cyclical tug-of-war between progressive legal reformers and traditionalist backlashes. When contemporary media presents the past as a uniform landscape of easily bypassed rules, it hides the immense structural labor that went into rewriting the legal definitions of family, property, and bodily autonomy. It downplays the reality that every single right modern citizens take for granted today was paid for with the systematic destruction of historical lives, fortunes, and reputations. When we view historical narratives through this unvarnished, deep-dive lens, we realize that the true value of historical fiction lies not in its ability to comfort us with familiar modern perspectives, but in its ability to shock us with the alien, unforgiving realities of the past. It forces us to confront the terrifying power that institutional systems can wield over individual human lives. It challenges us to ask how we would survive if we were stripped of our credit scores, our bank accounts, our legal identities, and our parental rights, leaving us with nothing but our raw wits and our survival instincts. As we reach the final destination of this masterclass series, we must synthesize everything we have uncovered across these 10 parts, moving from the legal fictions of contemporary literature to the definitive, step-by-step blueprint for constructing historically accurate, high-stakes narratives of marital dissolution. We must look at the ultimate checklist that every serious writer, reader, and historian must deploy to evaluate the authenticity of a historical journey, ensuring that the stories we tell honor the true cost of human liberty. Turn to Part 10 to unlock the ultimate masterclass blueprint. as we map out the definitive framework for charting the fictional divorce journey with flawless historical precision, bringing our epic investigation to its triumphant conclusion. We have arrived at the definitive testing ground where the abstract machinery of legal history transforms into an active, high-stakes engine for world-building and character development. To bring this deep dive masterclass to its absolute peak, we must synthesize every historical trend, geographic disparity, and institutional trap we have uncovered into an operational blueprint. Think of this final segment as the master builder's structural matrix. When analyzing or writing American historical fiction in the current year 2026, you cannot rely on emotional intuition. You must deploy a systematic, multi-tiered diagnostic checklist to ensure your narrative holds up under the rigorous scrutiny of historical fact. Let us execute a complete, step-by-step masterclass scenario to demonstrate exactly how this diagnostic framework functions in practice. Imagine a narrative project set in the United States in the year 1885. The character in question is a woman named Beatrice, born into an elite family in Charleston, South Carolina, but currently living with her husband, a volatile railway executive named Thomas, in Baltimore, Maryland. Beatrice has reached her breaking point due to Thomas's reckless financial speculation with her family inheritance and his flagrant, public infidelities with theater actresses. Step 1 of our diagnostic blueprint requires an absolute cross-reference of jurisdiction and timeline. A lazy contemporary narrative would simply have Beatrice pack her bags, consult a Baltimore lawyer, and secure a decree by the end of the year. Our masterclass matrix demands deeper excavation. In 1885, Maryland law did permit judicial divorce, but its statutory grounds were exceptionally narrow, requiring absolute, unassailable proof of adultery or uninterrupted desertion for a period of 3 full years. Cruelty was rarely accepted as a ground for absolute dissolution, usually resulting only in a legal separation from bed and board. Furthermore, South Carolina, where Beatrice's family wealth is physically tied up in real estate and trust funds, recognizes no judicial divorce whatsoever in 1885. This immediate structural friction provides the storyteller with genuine, organic narrative conflict. Beatrice cannot simply file papers. She is trapped by an intricate web of interstate statutory contradictions. If she sues for adultery in Maryland, she must navigate step 2 of our blueprint, the absolute exposure of the evidentiary phase. In 1885, Beatrice's legal team would have to hire undercover agents to raid Baltimore hotels, suborn testimony from coachmen and housemaids, and present these salacious details in an open, public courtroom. The potential outcomes of this choice are socially devastating. The local newspapers would seize upon the railway executive's scandal, printing Beatrice's private domestic misery across the front pages, effectively destroying her social capital and her family's standing in Charleston. This leads directly to step 3 of the masterclass matrix, the evaluation of the economic escape hatch. Imagine Beatrice realizes the social and legal cost of a Maryland trial is too high, prompting her to consider a migratory strategy. She looks westward toward the burgeoning divorce colonies of the frontier. To execute this, she must liquidate personal assets that her husband does not legally control under the evolving, but still highly restrictive Married Women's Property Acts of the era. She must board a train to a territory like Dakota or a lenient state like Indiana, establishing a physical domicile for the required statutory period. During this 6-month or 90-day waiting period, the narrative tension explodes. Beatrice is no longer just a passive victim of an unhappy marriage. She is an active operative executing a complex legal maneuver in a strange territory. She must manage local bank accounts, ensure she is seen daily by reliable local merchants to secure her residency witnesses, and constantly watch her back for private investigators sent by Thomas to document her migratory intent and invalidate her claim. This residency period becomes a crucible where her resourcefulness, her psychological endurance, and her financial survival instincts are tested to their absolute limits. Step 4 of our diagnostic framework forces us to confront the brutal realities of the material aftermath: child custody and asset division. If Beatrice successfully secures her Western decree, she must face the enforcement gap. The moment she returns eastward to claim her children or her remaining family property, she runs directly into the buzzsaw of state sovereignty and the doctrine of divisible divorce. Thomas can file an injunction in a Maryland court, claiming her Western divorce was a fraudulent evasion of local law. Under historical trends of the late 19th century, the Maryland judge could completely reject the validity of the Dakota decree, declaring Beatrice a bigamist if she remarries, and granting Thomas absolute, uncontested custody of their children as the wronged, resident father. By systematically applying this four-tiered matrix, geography, evidence, migration, and aftermath, the narrative completely sheds its anachronistic simplicity. The story of Beatrice transforms from a generic Victorian melodrama into a tense, high-stakes institutional thriller where every legal statute functions as a physical wall, and every choice carries a profound, permanent cost. This is how we honor the true lived experiences of the past. We do not sanitize the traps to make our modern audiences feel comfortable. We illuminate the sheer magnitude of the traps so that our audiences can truly marvel at the immense courage required to survive them. Case studies across 3 centuries of American legal history prove that the marital bond was never just a romantic contract. It was the foundational pillar of state control, property distribution, and social order. When a character attempts to sever that bond, they are not just leaving a partner. They are declaring war on the institutional architecture of their civilization. As historical trends shifted from the absolute indissolubility of the colonial South to the political theater of legislative divorces, through the public shaming of fault-based courtrooms, the radical frontier experiments of Sioux Falls and Reno, and finally to the administrative equality of the no-fault revolution, the core human desire for autonomy remained constant, constantly probing for cracks in the legal armor of the state. This concludes our 10-part deep dive masterclass into contextualizing the fictional divorce journey. You now possess the complete, unvarnished historical toolkit required to deconstruct any period narrative, identify anachronistic fallacies, and build authentic, high-stakes historical fiction that resonates with the raw, uncompromising truth of human endurance. The matrix is in your hands, the historical data is absolute, and the rules of historical storytelling have been permanently elevated. But our exploration of hidden histories and systemic cultural shifts does not end here. Turn to the next major investigation as we cross international borders to examine how these American legal battlegrounds clashed with the ancient, rigid matrimonial codes of Imperial Europe, triggering a global war over love, law, and liberty.